Hello, my name is Carolyn Anderson and I'm an advocate at Pacer Center. Welcome to our webinar on prior written notice. Prior written notice is an important right that parents of children receiving special education services should understand. This webinar will help you understand what the term means and why it is so important. First, prior written notice is an important right for parents of children with disabilities. The notice helps parents participate in all special education decision-making in a formal way. The notice is defined in both federal and state laws. It says that schools must give notice in writing to parents of a child with a disability in a reasonable time before they either propose or initiate a change, or if they refuse to take an action parents have requested. The word prior means before an action is taken or not taken. IDEA, the Individuals with Disability Education Act, requires that a school must notify parents in writing before a certain action occurs. So this written notice is referred to as the prior written notice. The notice must be given prior or before proposing or initiating a change in special education services, or when the school refuses to take an action parents have requested. The notice is given to the parents along with another form, the parental consent and objection form. The prior written notice gives the parents written information so that they can either agree or disagree on the consent and objection form. When is the school required to give the notice? The notice must be given before the school proposes or refuses to take certain actions. These actions include, first, identification. This means determining if a child may have a disability that may qualify for special education services. Second, evaluation and reevaluation. The school must give the parent notice prior to a child's initial evaluation for special education services. For a child already receiving special education services, a reevaluation is required every 3 years. The school must give notice before this evaluation will occur. If the school is refusing a parent's request to evaluate for special education, they must also give written notice of their refusal. Next, educational placement, which refers to where the child is going to receive the special education services. The school must give notice prior to changing the placement of a child's special education services or refusing a parent's request to change the placement. Finally, IDEA states that children receiving special education services have the right to FAPE. FAPE stands for Free, Appropriate, Public Education. This means special education and related services provided at no cost to the parents that meet the standards of the state education agency, in our state that's the Minnesota Department of Education, and provides appropriate services in conformity with the child's IEP. An additional time when the notice is required is if the parent is revoking consent for special education services. If a parent wishes to remove their child from special education, prior written notice is required before the school stops providing the special education services. When is the notice given? The school must give prior written notice to the parent within a reasonable time, and in no case less than 14 days before the effective date of change or evaluation. The notice may be given directly to the parent or mailed. The prior written notice will contain information in the required areas discussed on the next slides. The most common time a parent receives the notice is after the annual IEP meeting when a new IEP is proposed for the student. Anytime the school proposes to change the content of the IEP, parents must be provided with a copy of the proposal for consent. A typical change is when the school proposes a change in placement. If the notice only includes a refusal of a parent's request, the school must give a prior written notice within 14 days from when the request was made. For example, if you requested in writing to have your child evaluated for special education, but were verbally told that the school doesn't see a need to evaluate your child, the school must give the notice to you in writing on the prior written notice form of their refusal to evaluate and give you options for resolving this disagreement. What content is required on the prior written notice? The notice must include, first, a description of what the school is proposing or refusing. The Minnesota Department of Education guidance states that simply, quote, "see the attached IEP," unquote, may not be sufficient. Instead, the district should say something like, "The district is proposing to add 60 minutes per week of special education resource time for reading." Or, "The parent requested 60 minutes per week more of service time for reading, and the district is refusing this request." There will often be multiple descriptions of proposals and refusals in one notice. Second, an explanation of why the school is proposing the change or refusing to take the action requested. For each proposal and refusal described above, the district will briefly explain why they are making the decision. Using the example above, the school may say, quote, "We are proposing the additional resource time because the student is not making adequate progress." Or they may say, "We are refusing the parent's request for additional reading service because the child is making adequate progress on his speech goal." Or the school may say, the student has been identified as needing increased special education minutes because he has not been successful in his current educational program. He continues to struggle even with constant paraprofessional support. These are a couple of examples. Third, a description of the data the school used to make the determination to propose or refuse the action. Data can include information from sources such as evaluation, assessments, teacher reports or recommendations, IEP progress reports, observations, parent input, child social or cultural background, and report cards. Fourth, a statement that parents of a child with a disability have protection under procedural safeguards and how to get a copy. The procedural safeguards document gives parents help in understanding special education rights and protections. Fifth, the notice gives sources for parents to contact for assistance in understanding the notice. The notice should also include sources to contact if a parent needs help. Typically, the list includes Pacer Center, ARC Minnesota, Minnesota Association for Children's Mental Health, the Minnesota Disability Law Center, and the Minnesota Department of Education. 6. There will be a description of other options the IEP team considered and why they were rejected. Minnesota Department of Education guidance on this point notes that, quote, "Given the number of different people required to participate in IEP team meetings and the different roles they play, there should be no shortage of options considered." So, using the change of placement example again, one teacher may discuss continuing the current placement, an administrator may discuss pull-out programs at another school, and the parent may share recommendations from private therapy sessions. And finally, there will be a description of any other factors related to the school's proposal or refusal. For example, a student's need for frequent medical appointments might be a factor impacting the proposal that was not captured elsewhere on the notice. Minnesota statutes expand on the requirement of the notice under IDEA. So in Minnesota it includes that the notice must inform parents that the school will not proceed with conducting an initial special education evaluation or provide initial special education services without parent signature or consent. What this means is that if the school proposes to do an initial or beginning evaluation of your child, they can't go forward with the evaluation until you give them consent. Initial evaluation means that the child is new to the special education process. If a child is evaluated and found eligible for special education and related services, and the IEP team develops an IEP, the parent must sign and agree with the IEP before they can begin providing the initial service. So, for example, a school may recommend that a child be evaluated due to concerns with reading or math. If the parent says no in writing, the evaluation may not happen. If the parent says yes, the evaluation will occur, but if the child is eligible, no services can be given until the parent again says yes in writing. In the case of students who are already receiving special education services, the notice will also state that with the exception of the initial evaluation or initial placement, the school will go forward with what they are proposing or refusing unless the parent objects in writing on the response form within 14 calendar days of when the notice was sent or given to the parent. So, for example, your child is already receiving special education services and you just attended the annual IEP meeting. The IEP team determines changes are needed and the new IEP is sent to you for review. You have 14 calendar days from the day it was sent to you to agree or disagree with the proposal. If the school does not receive the form back from you with agreement or disagreement, those services will still go into effect once the 14 days have passed. The school must also inform parents that if you object to a proposal or refusal in the notice, you must have the opportunity for a conciliation conference. If parents disagree on the consent form within the 14 calendar days of receiving the notice, the school must give you the opportunity for a conciliation conference. A conciliation conference is a meeting that gives parents the opportunity to meet with appropriate district staff to discuss their reasons for the disagreement and try to reach an agreement. The conference must be held within 10 calendar days from the receipt of the parent's disagreement or request to participate in a conciliation conference. The notice will also give information on other dispute resolution options to resolve the disagreement, such as mediation and facilitated IEP meetings. The notice must be written in a language that's understandable to the public and in the native language of the parent or other mode of communication used by the parent, if possible. If the parent does not have a written language, the school must translate the information orally or provide it in a way that the parents communicate. The school must be sure that the parents understand the notice and write down that the school has done these things to make sure. If you have any questions about the webinar or the information you just received, you can contact PACER and ask to speak to an advocate. You may also check out the other resources listed above. PACER Center is Minnesota's Parent Training and Information Center. We provide individual assistance, workshops, publications, and other resources to help families make decisions about education and other services for their child or young adult with disabilities. Feel free to contact us. Finally, please take a moment to fill out the brief evaluation form when you complete this webinar. Thank you.